If an actual conflict arises between two co-defendants tried together during the summation of a co-defendant, does that justify the granting of a severance motion? To find out, you have to read People versus Everson. But it's 7 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Everson. The citation for this case is 2025, New York Subopinion 05738, published by the New York Court of Appeals on October 16th of 2025. The issue in this case is whether a severance motion is warranted to sever the trial of two different co-defendants based upon something a co-defendant's attorney says in summation. To understand and appreciate the background of this case, the helpful part to know is that under CPL 200.40, Criminal Procedure Law 200.40, it says that it describes indictments and what happens when you have multiple defendants on an indictment. That's fine. It's allowed. And it describes how a severance application can be made. Severance, meaning separate trials between co-defendants. So each defendant would get their own trial outside to a different finder of fact, a different jury, and all that. That can be warranted, and it's in the discretion of the court when, based upon good cause, and essentially it's when there has to be a finding that either the defendant or the people will be unduly prejudiced by a joint trial. Okay, and case law has developed that shows that there's a 2-part test to this. It's the case of Mabubian, and the 2-part test says severance should be granted when the core of each defense is in irreconcilable conflict with the other, and where there's a significant danger, as both defenses are portrayed to the trial court, that the conflict alone would lead the jury to infer the defendant's guilt. So if you have two defendants and there's a shooting and they're tried together and their defenses each, the other guy shot him, that would be an irreconcilable conflict, and the danger would be that the defenses presented together would lead the defendant to infer each defendant's guilt, right? That's an example of the Mabubian doctrine, the 2-part test. The facts in this case, facts are that allegedly on the early morning hours of July 13th, 2019, the defendant, Everson, was with two co-defendants in a car, and they were driving around a neighborhood, and two different guns, two people in that car allegedly, shot at a crowd of people, killing someone in the crowd, allegedly for an incident that occurred a couple days earlier, where someone in the defendant's group had been shot. The two defendants here were charged in a single indictment with murder in the second degree and 4 counts of criminal possession of a weapon in the second degree. Before the trial, 6 days before the trial, defendant Everson moved for severance. He said, I want to be tried separately from my co-defendant. Defendant said the trial should be severed because Bordy's counsel, his co-defendant's counsel, intended to argue the defendant was responsible for the shooting, just like we talked about in that hypothetical. The court then denied the severance motion. The court denied the motion, saying, we'll see what happens. Said there was insufficient specificity as to what the defense was, how it was going to come out, and the judge said, "We'll see how it goes." The court specifically said, he said it was speculative, and he said, if and when this comes about, I'll have to deal with it at that point in time. During the trial, testimony came in, and no testimony. The defendants didn't call any witnesses. The defendant did not wind up bring out any irreconcilable conflict during the trial until the closing argument. In the closing argument, Everson's co-defendant's counsel said, essentially, this is what he said. We know 2 things for sure about the car. Shots came from it, and there were 2 guns. There's 2 guns. There's 3 people in the vehicle. Okay, so how did we know who did it? Well, we know one of those persons that had the gun. That's the person who confessed to his girlfriend that he did it. We know that one of the shooters was Mr. Everson because he told his girlfriend that. Okay, that was what the co-defendant's lawyer said in summation. There's a general instruction given to the jury that what the attorneys say in the closing argument is not evidence. It's an argument. Ultimately, the defendant was guilty. Everson was found guilty by the jury and was convicted. And then he appealed. And he said, I was entitled to my severance. He brought it up after the summation. The judge denied it. And he says that was error. I should have been given a separate trial. The Appellate Division here affirmed the conviction, said that rejected that the county court abuses discretion in denying the motion to sever. It goes to the Court of Appeals. And the question here is the The actual conflict here was raised only in summation for the first time. Is that sufficient? Nothing happened in their trial that would have justified severance, allegedly. The only thing that would have justified severance is the argument made by co-defendant's counsel. And the answer from the Court of Appeals is that is not sufficient. That is not appropriate. It says, no actual prejudice was created by co-defendant's closing argument here. The trial court properly instructed the jury that the attorney's arguments are not evidence. And the very type of discord that would justify severance cannot be raised for the first time in argument in closing. That's not sufficient to show abusive discretion on the part of the court in denying severance at that time. And that's the case of People versus Everson. The holding here, a conflict between co-defendants that's raised for the first time actually in summation is not sufficient to warrant severance.
If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.